Hello, everyone, and welcome to this summer version of the Lost Side of Nunavut's CLA Lunch and Learn series. Thank you all for being here, and thank you especially to Andrea Clark, who is our presenter this morning. Andrea is a lawyer who practices in multiple jurisdictions, including in Nunavut, and we'll be talking this morning about specifically the family law context in Nunavut. And we're very grateful to Andrea for presenting. And as is always the case, the views of the presenter are theirs alone and not official policy statements by the Law Society of Nunavut. We are always grateful to our presenters and for their pro bono contributions. And Andrea, thank you again for being here. And without further ado, I will hand it over to you.
You very much for having me. A little bit about myself before I launch into my presentation. I spent some time practicing over in the UK, in the United Kingdom, where I did my law school, and primarily in the area of law at that time. I returned to practice and continued to practice in Ontario. I sit on the Office of the Children's Lawyer as a panel member, and I do primarily family, criminal, and child protection work. And I also practice here in Nunavut. Today, really what my discussion is based upon is going to be the importance of understanding culture and the cultural context in which we advocate for our clients, and the importance of us coming to and understanding lived experiences. Primarily when we look at legislation concerning children, that best interest is what is key. That played out in CRA, it's played out in the CUFSA and the Child and Family Services Act. And fundamentally, whether we're looking at parenting decisions and there's a breakdown of relationship, or whether we're looking at protection cases and where the children are going to be placed, the primary factor comes down to what is the best interest of the children. I will talk a little bit, and perhaps it was a bit of a story about the importance of being able to recognize the cultural sensitive when we have children of different backgrounds. I just finished my final year of law school, and that was in a city called Birmingham in England, referred to as the second city. So you have London, you have Birmingham, you have places like Manchester, Newcastle. And many of my counterparts who had completed law school that year had made the decision that they were going to venture off into corporate law. And I too had thought that that was going to be my path. So that summer, I had a employment opportunity lined up for the fall, but thought that that summer I was going to spend some time volunteering. An opportunity came up to do so with a nonprofit organization that effectively worked within the inner city of Birmingham. So for a little bit of context, that environment was one that was different than where I had studied. So the outskirts of Birmingham is an affluent area. The inner city itself is a place in which 50% of children are living below the poverty line, and it was marred by gang and gun violence. The program that I was going to be helping with or presenting effectively was one in which youth between ages 12 to 17, so preteens, teens, were going to be introduced to the justice system through the construction of music and comparing advocacy skills with what expression in various forms of music are. So I arrived on the first day to present to these young people, and they had some excitement and were somewhat giddy because of the fact that they viewed my accent to be American and certainly not. Nonetheless, we got past that. What became very interesting to me was the background of these young people. And over the week that the program ran, I got to know better. There was a young girl who's 13 who wanted to be a writer. However, she struggled with confidence knowing whether she could do it. There was a girl who was 17, and she wanted to enter into the legal system. She hoped to be judged. The challenge with that is when you come from certain backgrounds, it becomes extremely hard to believe that you can be something that you cannot see. There was one young boy, and I don't know why um, there was one boy who had was uncertain about the future perhaps had held for him, because of the fact that for him, all of the interactions he had with the male peers in his life had been through the criminal justice system. So he had a whole degree of uncertainty as to what had lay ahead for him. Over the weeks, we got to know each other better and developed a rapport. Interestingly enough, one evening, as the program had come to an end day, one of the young girls was walking, and she was doing so in what I thought was not the shortest path to get to her residence. As I felt that there was an obligation to ensure that these young people got home safely, the next day I asked her about it. And her response was trusting. There was a pause when she then said to me, "You're right. The path that I was traveling wasn't the shortest, but it was the safest." And that was something that perhaps stuck with me and has changed the way I practice law. Because although I had gone into a situation under the belief and guise that I knew better, there was a cultural discrepancy in the environment that these young people were used to. And they had a lived experience that was not shared. And as a result of that, when I deal with cases, either in the family law context or in the child protection context, I recognize and acknowledge the importance of those who have a lived experience different to those who are advocating on their behalf and those who are the decision makers. So it's also perhaps particularly important to understand that when we talk about particularly child protection matters, we're looking at overrepresentation of both Indigenous and Afro-Canadians within these systems. And when I say overrepresentation, it is pretty significant. In 2022, it was believed that 58% of children between 0 and 14 in care were Indigenous. That's an alarming number when we talk about them, Indigenous children only making up 7.7% of the child population. So there is something that goes horribly wrong, and it's probably not one thing. The interesting matter is that we have legislation that is quite clear when it lists the factors to be taken into consideration, either through ultimately making a decision concerning parenting decisions, or when we're looking at where the child is going to be placed in relation to child protection matters. Part of the challenge is understanding how and what weight is given to factors of culture, heritage, and language, the importance that is placed upon it by decision makers, and as advocates, how we come to it to ensure that we do the best we can for our clients. So the starting point I come to advocate in cultural context is important for me is I get the opportunity for those with the lived experience to tell me their story. What has become extraordinarily humbling for me, from my purview in any event, is when I have that opportunity and it's not a shared lived experience from my perspective, is to have the humility to know and understand exactly how much I do not know and understand. Because when I hear the narrative that's being told, and more that I hear and understand, the more that I'm able to advocate from a perspective that takes into account their cultural lens. And if I can do that, I become a far more impactful and effective advocate. I certainly, in both child protection and family matters, note the importance that the legislation in one aspect gives to culture and heritage. The challenge with it is when you have legislation which effectively states, as the CLRA does, that you are visible, we acknowledge it. Well, that in itself, we can come to a consensus is good. However, if it's not properly applied, it can become more harmful than beneficial. So the challenge is when we acknowledge the importance of aspects of culture, heritage, and language, but we don't give it the weight it deserves, or it doesn't factor into the consideration significantly enough. What we effectively have done is acknowledge visibility, really given it no power, and it becomes performative, or in some respects, we becomes more oppressive than helpful. And I see that for these reasons. For those who have come from racialized backgrounds or cultures, we understand that when there has been a systematic approach to um, assist or to recognize or to acknowledge, if it's not genuinely and properly applied, what we do is we add to the problem. So when we have a scenario where I look at child protection matters, whether that's through lens as a panel member of the Office of the Children's Lawyer or as an advocate on behalf of the families, when we step in halfway through a story without acknowledging the harm that has already been done to certain racialized groups, and without advocating for earlier interventions with necessary supports. So when I have a case where we have children of child and family services coming in at a stage that they're looking to apprehend children for marginalized or racialized Indigenous groups, the challenge from my perspective is we have then utilized legislation in a manner that furthers oppression instead of offering the assistance and support that's required as a result and in the context of the history and struggles. Do I advocate for children to go back to unsafe environments? No. But if we only ever focus on a part of the legislation and only focus on a lens which does not serve the full purpose of the legislation, then we end up doing more harm to a group that has historically been harmed. So as advocate, when we look at advocating where culture becomes a significant portion or a part of what we are bringing forward to the court, it's important that we understand the context. I say this. We need to understand the narrative that our clients are coming from, their perspective. We need to understand as best as we can within our limited capabilities the history. Because coming in partway through a story, as I've stated, can be more harmful than beneficial. We also then need to understand how that narrative and story fits into the legislation and the purpose of the legislation. If we understand the significance of heritage and culture and the purpose of the legislation when we look in terms of particularly protection matters, it is going to be the reunification of families whenever possible. If there isn't early intervention, so I often have cases where in Ontario, Children's Aid has come in and effectively what they say to the court is parents have failed to meaningfully engage or the parents don't have an adequate plan for protection. The challenge with that always from my purview is the onus lies where there is a power imbalance on the society. The onus lies with those who are working, the Children's Aid Society workers, of early intervention and engaging with parents to offer them supports. Because historically, we know how there has been a systematic mistrust and unconscious bias in a system that has not worked in favor of those who are most marginalized and vulnerable. And so when I'm effectively advocating and putting the narrative before the court, the thrust of it is not only going through the conditions as listed through the legislation, but also providing very contextual narrative of the family's lived experiences, their own struggles, and the lack at times of setting realistic expectations and providing the necessary supports. As we all know, legislation is very clear that apprehension of children should always be the last resort. We first look at the least intrusive method in which we can protect the children, but effectively align, support the autonomy of the family unit. That's one aspect. Something I'm very passionate about because I think there are some missed opportunities with both advocates and decision makers in come to the table when we don't fully understand the background of those who are before us and how best we can serve them. It certainly is not intentional, and I would never suggest that the intention by those who are advocating apprehension is to cause more harm, But unless we understand history, we're doomed to repeat it. And there should always be push for a collaborative effort. And that really comes about by all parties making concerted effort to understand through another perspective in terms of contextual lenses. So I'm reference to the Children's Law Reform Act, it's the CLRA. And we know that paragraph 53 particularly makes reference when we're dealing with Indigenous children and the factors that should be considered, which includes heritage, culture, and language. That was set out in one of the cases we'll be discussing. We're aware that that is section 24 of the CLRA. And it seems to be of considerable importance. And once again, the challenge with that is knowing the weight that those factors are given. What perhaps has given some more significance when we're looking particularly with First Nations, Inuit, and Métis children is the federal acts. We refer to it. We know that the Supreme Court decision came out last year upholding aspects of the federal act. There was a particular case that came out of the Court of Appeal in 2022, and that's the Liko and Nash case. That was a case dealing with Indigenous parties. And out of that case, it was directed that the courts were to interpret the best interest provisions to incorporate them in national standards that were set out in the Federal Act in a manner that harmonizes the legislation. Such the best interest tests pertaining to Indigenous children became more expansive than that set out in section 24.3 of the CLRA. The court must, in addition to that, consider UN documents that have both been incorporated into the legislation. But it comes back really how best we serve our clients and what is the actual test, what is the weight that's given to it. So what has been set out in that case, where the best interest test must address the rights of Indigenous children, which include the recognition of equality and a unique heritage culture and language. And so what I have often advocated for are those points, the points effectively of the uniqueness of the heritage and culture. What I've tried to expand on and what I have often struggled with is it's well and good to state that those factors need to be taken into consideration because that's proper and correct. Perhaps more of the concern for me is if we don't understand the significance of those factors and how they play into the lived experiences of clients, we do a disservice in advocating on their behalf. We also do a disservice in terms of advocating for the weight that those factors should play into the consideration when we're looking at Indigenous communities in particular, but also maybe racialized groups or marginalized groups. The case which I make a reference to, Justice Gordon, in that was very specific in stating that Indigenous child is allowed and encouraged to learn and participate in his or her heritage, culture, traditions, and language, and to preserve the acquired identity of the community or nation to which he or she belongs. In that particular case, both parents were Indigenous and they identified as so there was perhaps less consideration and relevance to the CLRA factors. And Justice Gordon, in that case, made specific note of that. He noted that the following factors were not relevant, and that was each parent's new relationship, as there were complaints, their religion, because parties had identified with traditional Indigenous spirituality, substance abuse and suicides, which had been a community problem, was a factor. In a family issue, he made the particular note would lead negative inferences. As such, that was not considered. So this had been a case about parents who had been sharing time effectively, and now there was going to be a move a few hours away. So what was helpful to a certain extent was the fact that he went through the factors that he thought were particularly relevant, as I said, because the parties were both Indigenous. It perhaps played out a little different than we often have in some of the protection cases, or where one parent does not come from the same cultural background. Ultimately, in this case, Justice had gone through each of the factors and the consideration given, which was helpful, and the court ultimately ruled that the mother simply presented a more stable plan, and as such, the child would reside primarily with mother. Father was going to get an increase in parent time than what had been proposed. The factors, when I look at this from, I suppose, an advocate's perspective, and particularly when the backdrop is one where some of the issues are not relatable, there's extra care that needs to be taken, and there's going to be the need to establish a trust base when we are representing communities that have certain vulnerabilities, or we are presenting clients who are particularly vulnerable. And for many of us who are aware of past injustice in many of these communities, we can understand from overarching principle why there may be inherent mistrust. And there, at the start of that, really is the opportunity to try and manage some of the distrust. And that starts even before we're able to try and build a relationship based on trust. So the conversations that I sometimes have when we look at child protection proceedings, and we have girls who have come in with a certain contextual view, as I make reference to perhaps midway through a contextual story, and are advocating for a particular outcome, I try and highlight that it is far more beneficial for there to be a system built on trust. And the start of it is going to be challenging, and it really will be dealing or managing to a certain extent some of the mistrust systematically, not in relation to particular groups, but a system that has repeatedly failed some of our most vulnerable groups and demographic. We are now left in a position we have to rebuild. And from an advocating perspective, when I go into court, I do my best to lay that out front. That it's easy to get caught up in a narrative of a parent who has struggled with the expectations that this society has placed on them. But if we do that not in the context of their backgrounds, we do them a disservice, and we're not properly applying the legislation. So we look at parents, or when I look at parents from particular communities that may be dealing with addiction issues, and those addiction issues may have arisen from past traumatic experiences. Uh, and we have now gone to a stage where there's intervention from Child and Family Services or the Children's Aid Society. We have to look at how we support those parents in a meaningful way. Part of the challenge I have experienced has been ensuring that there's a meaningful attempt at engaging parents and that it doesn't become a tick box exercise and more performative, because once again, that then adds to the already traumatic experience. In Ontario, where I do a lot of my practice, when we talk about Black communities or those that are polarized, and we look at kin placements because Blacks have been overrepresented again, although in terms of protection matters. So kin placements, I think most of us in protection will say that if the child has to be removed, placing them with family member, we know statistically the outcome is better than having them in foster care. So the avenue that is most preferred is looking for kin placements. Challenge is when kin placements or applications for kin placements are done, there is criminal background checks that are to be done. And within the Afro-Canadian community, that is a red flag. It's a challenge because institutionally, there has been oppressive nature with regards to the interactions with police and the Afro-Canadian community. So you have problems before you start. You have the issue of many decent and good homes for kin placements, family members don't wish to even engage in the process of a kinship process because they don't want to engage in a system that has failed them. And if it hasn't directly failed them, there will undoubtedly be a story as to the impact it has had on parents or grandparents. And secondly, those who come forward and are prepared to engage in the process, the challenge that often we find is that they won't pass a kinship assessment because they may very well have had problems with the law. When we see a system where there's an overrepresentation in the criminal justice system, both Indigenous and Blacks, likelihood is many of them down the line will have challenges passing any assessments that require criminal background check. And that plays in, once again, to institutionally contributing to trauma that has already been suffered. So from my purview, I encourage child protection workers to look at avenues that come outside the box. If there are decent and good family members who are prepared and willing to take children so they're not having to be in care, then that should be the priority and the thrust of what we work towards, irrespective of whether we tick all of the boxes on the paper concerning background checks. And by no means misinterpret what I'm saying. The criminal background checks are there for a purpose to do our due diligence, ensuring that that is a safe environment for the children to be placed in. However, part of what I say is that there is a cultural context to understanding why there is a challenge in certain communities successfully having kinship placements. And if we are open and can understand how those challenges and contextually why those challenges arise, a part of our obligation, responsibility, in my view, is to best see how we can work to find solution to those challenges. The concern I have, and I've been an advocate for for a long period of time about ensuring that we step back when there is a culture that we're going into or an environment that is different than ours, and we allow those who live it and have lived it to explain and to lead the way. Because when we go in robustly, whether it's through our representation in court or whether we're talking about those who are working with these families in a child protection sense, when we go in robustly without acknowledging the harm that they have experienced at the hands of a system that has failed, we add trauma to that. So you can envision and imagine a scenario where, and it's certainly not unusual. I had clients who are they're survivors of the residential school system, whose parents or grandparents were, but have had a direct impact because, of course, that type of trauma, unless there's proper intervention, it becomes generational trauma, becomes a part of the legacy. And as a result of that, I've had cases where there have been addiction issues that have developed because there has not been early or proper intervention support. And then we get to a challenging scenario where the addiction becomes unmanageable. And we have a system that then comes in and says, we're going to apprehending your children, and that's in the best interest. And what we do in those cases, if the children are apprehended, compounding the trauma that has already been experienced. So early intervention, all the supports, we're certainly, I will acknowledge, making some headway in understanding better and looking at alternative options as to how to place. But I still, from my purview, my own practice, have concerns where that a sufficient weight is not given to culture and heritage and ensuring that even when there is a placement that is perhaps not of the same cultural background, that access and a plan of access is followed through to ensure that these children are able to continue with their access to not only their own community, culture, and heritage, but it's encouraged. So I'm just going to perhaps go through a little bit more with regards to some legislation we've heard, as I made mention to the federal act and the Supreme Court ruling last year that had provided further enhancement. We're looking at it in the Indigenous Child and Family Services into the factors to be considered, and perhaps gives it more of a push of the importance culturally to the weight it should be provided with. And in addition to that, the additional documentation that should be considered when we're looking at best interest of the children. I have recently dealt with certain cases where, there's a lot of work that I find that we're now trying to push for behind the scenes to see whether or not we can take matters out of the judicial system, because that system isn't a system, certainly from my view, that works best for some of the most vulnerable in our society. And interestingly enough, many will remember the Canadian Ontario Human Rights Tribunal in 2016 found that the federal government had discriminated against First Nations on the reserve through their design, management, control, and funding of child welfare services. And part of the challenge is when you have those systematic failures, it becomes increasingly challenging to identify the problem. We all say we know that there is a problem. The challenge is how do we move forward? How do we fix the problem? And what's the pathway ahead? And some of that comes through training, not just with advocates, but everyone that's a party to the intervention. So certainly with lawyers, those who are the decision makers, those who are working with the families, there's an element of having to have the training, but training in itself, we must recognize has its limitations. And I say that because there's just certain aspects of culture, if you don't have the lived experience, that you will always be limited with. And I can appreciate that. But from a racialized community, I can also appreciate the challenges it is when those who don't share the lived experience comes in and with the best intentions in the world are advocating for a path or a system that doesn't fit the culture. Among the so with regards to the Canadian Human Rights Tribunal and that landmark funding, among the discriminatory impacts were that the federal government didn't provide adequate funding for prevention services. And that has been a consistent call line by the time that we get to board is that this is wholly unhelpful when we are in the system. We need preventative services and we need to be working culturally and weighing that pretty significantly when we have children that are from varying and diverse backgrounds. And part of the finding in this as well is that there was incentives placed for placing children in care by reimbursing certain costs. And whether that was intentional or unintentional, I think that's part of the problems we have, either unconscious bias or we have a systematic failures, is the impact is not always easily identifiable until after the fact. Many of us will also remember the Mother Risk Commission came out in 2016, and that had been a commission to review the mother risk laboratory findings, which had been set up at the Toronto Sick Children's Hospital. It was actively using hair samples to test for drug and alcohol. And there had been a call for these samples to be used in child protection proceedings. And they had used for 20 plus years in child protection proceedings, establishing alcohol drug use. It was years later that came to light of exposure to unreliability. The problem is that children had been permanently removed as a result of this evidence. The impact was greatest on the Indigenous community. And one of the things that came out in terms of the recommendation by the Honorable Justice Lang from that was the need in child protection proceedings, when we're looking at best interest, and we have expert evidence, for there to be robust scrutiny of expert evidence. Child protection proceedings particularly has been somewhat more flexible with the admissibility of evidence. And that can be understood because those proceedings in the very nature of them is effectively to make quick decisions if they're a child that needs protection. and to avoid unnecessary delays. And so it follows a very different system than the criminal justice system has on with regards to the scrutiny, testing, and the foundation that needs to be laid for expert evidence. But one of the calls out of that commission was the need to ensure that we scrutinize robustly expert evidence that we're relying on for child protection cases. But I think from my perspective, what also came out of that was the impact on some of the most vulnerable, once again, in our population demographic. And there's no going back when you have scenarios where you're meant to be looking at the best interest of the children and they are permanently removed. The impact can't be reversed. You don't have that option. So when we talk about the significance as advocates coming to the table where we are advocating on the best interest of the children, it is so important for us to be knowledgeable as best we can about their background, their story, the importance of their culture and history, because that weighs and should weigh significantly in any termination for those kids. I note the time, and I think I'm gonna leave it open. If there are any questions? I'm just, I don't know if anyone does have any questions.
I wonder if could I ask a question?
Or
So I know there have been recent legislative changes with respect to child protection, and I'm wondering if, you would comment on to what extent, if at all, they're helpful with respect to this, deeper understanding that you've articulated so well as necessary with respect to people's context.
the challenge I've had with legislation has been it is only as good as it is applied. So part of the consideration is that often we don't know the weight that the factors are play into the determination, the ultimate determination. So when we look at the expansive nature that is out for Indigenous children, I do think it helps to certainly focus the mind on the aspects that need to be addressed. But ultimately, there is still perhaps some work to be done in understanding from the decision maker's point of view as to the way I appreciate it's so a lot it's very fact specific. So there will be many factors in consideration that weighs in. I suppose I note that the application of it is perhaps more important than simply having the list of factors.
Thank
Any
you.
any other questions? Doesn't seem like there are.
Well, we are approaching the hour, and I people generally, don't mind having a few minutes back of their time. So thank you again for your very thoughtful discussion today, Andrea, and we really appreciate you taking the time and again, please do, for the folks who are attending, we do have other CLE offerings on the Lost Society of Nunavut website as well. If you are looking to make up your CLE hours, we do have this, and other sessions will be recorded. So you can watch it again if you missed anything, or you can look at other sessions as well. So thank you again. Andrea, did you have any sort of parting thoughts, closing words?
I don't, the only thing I would say is that when we are just be mindful, I think, of those that we're presenting, and they trust us to represent them. I know that goes out saying, but if we can take the time to try and understand a little more about their culture and background, I think we will be more effective. Thank you.
Thank you. Such an important perspective. Thank you again for your time, and thank you everyone for attending.